And let us discuss about the judicial department. Okay, so of course, the judiciary, the particular provision as to the judiciary can be located in your Article 8 of your 1987 Constitution. Okay, so of course, I think we have this. We have already discussed some of this in our discussion on judicial review. Diba? So judicial power lies before the Supreme Court, di ba? So as to any other courts as may be conferred by the law, okay? So, of course, the discussion natin sa judicial department, I think I would assume that you have discussed sa inyong mga sa remedial law yung concept ng jurisdiction at saka yung structure ng judiciary natin. But just to give an overview, of course, the Supreme Court is the supreme the ano is the Supreme Court is the highest court in the land, okay? Pero syempre we have to of course consider syempre si BP 129, 'di ba? So si BP 129 is the one who created the BP 129 is the current law with respect to jurisdictions of courts, okay? So 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 of course how are we going to discuss the judicial department? So of course let's discuss first a little bit of the hierarchy, but I'm not going to go deep into that because of course remedial law has kind of this has made you consider this when you discuss jurisdiction. Then of course we discuss of course the general powers of the Supreme Court. So of course we have BP 129. So we there is the creation of lower courts, then up to the appellate courts. Okay, so as of now, the structure of our courts is, of course, the lower courts would be either a first level court or a second level court. A first level court is an MTC. MTC in a sense that it can be a metropolitan trial court, municipal trial court in cities, municipal circuit trial court. Okay, so that's your first level court because there are cases which you should file in those first level courts. That's the courts where they have jurisdiction. Then we have second level courts. We have the regional trial courts. So they also have jurisdiction over original cases, okay, be it civil or criminal. Then we go up to the hierarchy. We have our appellate courts. Okay, so your appellate court generally is the court of appeals. So this is where appeals are made. Then if the appeal is not going to prosper or there is a dissatisfaction of the appeal, you now go up to the Supreme Court. So the Supreme Court is the final arbiter, the highest court in the land. Okay, so that's the hierarchy of the courts. Now, of course, aside from these courts, there are other specialized courts. Now, depending on how the Constitution or the law assigns it, di ba? It is significant. For example, the Sandigan Bayan. Sandigan Bayan is a special court which specializes in criminal cases involving public officers. Medyo nasa between siya kasi meron siyang mga functions na appellate at the same time trial like your first and second level courts. Okay? So yun yung mga special. Also another court which is also special is the Court of Tax Appeals, di ba? So si Court of Tax Appeals pag may mga issues on taxes, may hierarchy na going up to the Court of Tax Appeals, going to the Supreme Court. Okay? Most of the recent legislation, particularly if you read si RA 90 to 82, hindi na dumadaan halos na CA. So, from CTA, kasi nag-create ng CTA and bank. So, the division may decide, then the end bank of CTA would decide further before going up to the Supreme Court. So, ganun ngayon ang structure and hierarchy sa tax appealing. Okay? So, alright. Then, of course, judicial powers. Okay? And jurisdiction. So, we have Article 8, Section 5. Okay? But before we go to Article 8, Section 5, we have to consider another feature of our judiciary. Other features. So, unahin nating discuss is, syempre, una is yung concept ng fiscal autonomy. I think we have kind of touched this in Francisco versus House of Representatives. So, ano ibig sabihin ng fiscal autonomy? It's the power, the Supreme Court has the power to generate its own income. Okay? Pwede siya mag-generate ng own income. So, paano ba yung income generation? Maraming ways. Like fines. Nakikita nyo, may fines sa courts, di ba? or nagsisingil sila ng mga development funds like the JDF or mga sheriff's funds. May power kasi ang Supreme Court to generate income because they have fiscal autonomy. Okay? And even even Congress and even the President cannot question that. Okay? Malinaw naman sa Francisco versus House of Representatives and that fiscal autonomy of the Supreme Court is something which is important to the Supreme Court. Okay? So, yun yung difference niyan. Yun yung pinaka-emphasis. So, they can generate their own funds. They can spend it without, of course, subject to the proper auditing. But the point is, they have this control over their budget. Okay? Then, we have the Judicial and Bar Council. Okay? So, ano tong Judicial and Bar Council na to? Okay? Just to give you a background. Okay? Just to give you a background. Siyempre, si Judicial and Bar Council was a creature of the 1987 Constitution. Previously kasi, under the 1935 Constitution, justices of the Supreme Court are subject to the Commission of Appointments. So, yung listahan nyo sa Section 16 dati, may SC yan. Noong panahon ng 1935. Then came martial law. Diba? Nung martial law, diba, walang Congress. So, what happened was, well, Congress, siyempre, Marcos is a one-man army. Siya yung presidente, siya rin prime minister, siya legislative, di ba? So, nangyari, siya rin nag-appoint noon ng courts, ng judges and justices. Wala pang formal structure noon kasi ng how judges are appointment. Noon naman kasi, although ngayon naman, totoo pa naman, it still goes to the president for oath for signature. Pero, although it goes to the president for final determination, judiciary pa rin yung mag-oath doon, di ba? So that's so ngayon, because of what happened during martial law, nagkaroon syempre, well, of course indirectly, na parang, well, control ng executive yung judiciary. So hindi independent yung judiciary for all intents and purposes. So what they did was they created this new office in the Constitution, yung Judicial and Bar Council. So, yung Judicial and Bar Council, may composition yan. May composition ng senator yan, congressman, member ng IBP, representative ng IBP, representative ng student ng other sectors, 'di ba? So may composition yang si JBC, okay? So siyempre, anong role ng JBC? So sila yung magfi-filter ng appointments. So, pagka-filter ng appointments, di magkakaroon ng interviews. So, nakikita niyo may mga interview sa JBC, di ba? So, after nun, magkakaroon sila ngayon ng shortlist. So, usually shortlist yan, 3 nominees ang shortlist niyan. Pero, yung shortlist na yon is a recommendation at who to appoint. Ngayon, yung shortlist na yon ibibigay sa presidente. Presidente ngayon ang pipili. Kahit sino doon. Pero hindi siya pwedeng pumili outside the shortlist. Di ba? So, yun yung point ni JBC. So si JBC magse-select ng qualified, then, subject to the approval of the president, sinong pipiliin niya dun sa 3 qualified. Okay? So, yun yung JBC. Okay? That's how the JBC works. Okay? Now, limitations of the JBC. Ang emphasize natin yung kaso ni De Castro. I think it's De Castro it's the De Castro case, okay? Relate natin to dun sa issue ng appointments, yung midnight appointments na dinidiscuss natin, okay? Kasi 'di ba, for all intents and purposes, 'di ba, mag-appoint pa rin ng judiciary is the President of the Philippines. Ang next question now is, covered ba siya sa prohibitive appointments under doon sa Article 7 na diniscuss natin, Section 15, yung bawal yung appointment within 2 months. Ay, di ba, within 2 months from the preceding election, hindi pwede mag-appoint ng kahit sino ang presidente. Okay? Ang tanong ngayon is, covered ba ang appointment sa judiciary? That's the case that was decided in the aftermath of Justice Puno's retirement. So, gustong i-appoint ni PGMA si Justice Corona. Di ba? So, yun yung nangyari. Gusto niya i-appoint si Justice Corona. Ang problem was, di ba, in-appoint niya si Justice Corona a day after the election. So 2010 election, inappoint niya after na election. It's within the 2-month period, 'di ba? Nung ban sa Article 7 Section 15, 'di ba? So nandun siya sa ban. So ang question is, kasama ba sa ban ang Supreme Court justices? Appointment ng Supreme Court justices. Dati kasi may ruling ang Supreme Court diyan, si Inre Mateo Valenzuela. Sabi nila, oo, kasama ang appointment ng judges sa prohibition ng ban. So, may dating kaso yan si Inre Mateo Valenzuela. This has been overturned in I think the case is De Castro versus JBC. Sabi ng Supreme Court, iba yung importation. It's time for, number one, it's time for Inre Valenzuela to be revisited. So sabi nila, well, iba yung appointment process kasi ng JBC, 'di ba? Kasi 'di ba meron silang testing, may screening sila at all of that. So it's different to the appointments being made by the president in his exercise of its executive function. So covered lang nung mga appointments niya sa executive function yung ban yung 2-month ban under Article 7 Section 15. Hindi kasama ang justices. Kasi of course, they went back to history na, oo, covered dati ang judiciary. And so far as appointments to them na ina-affirm ng Commission on Appointments. But since it's the JBC who is now doing the selection, it doesn't find any reason that the Supreme Court is included in the prohibition when it only applies to the executive departments, 'di ba? So, 'yun. So, 'yun yung isang crucial part ng sa JBC. It's a different body that is distinct and separate from that it can be separated from the prohibition from appointments, okay? All right. Okay. Now, we now go to section 5, okay? Article 8, section 5. So, naka-enumerate dyan yung powers ng Supreme Court. Siyempre, yung first two, jurisdiction yun, di ba? Yung original jurisdiction ng Supreme Court yan. So, certiorari petition. Pero focus tayo sa other aspects. So, yun, I would assume you already discussed that in remedial law, okay? Yung original jurisdiction, appellate jurisdiction ng Supreme Court. That will be your Section 5, 1, and 2. Okay, so I'm not going to, let's not dwell on that much. Okay, so of course, yung number 3 mo is you assign temporarily judges of lower court. So napapansin niyo to kung nasa court kayo lagi. May pag wala pang available vacancy, nagkakaroon ng acting capacities yung other judges. There are some judges that are being assigned in faraway places. Minsan, I recall I have this judge before na nasa Pasig ako, but he came all the way from Baguio, pumupunta pa siya ng Pasig para umattend ng hearing. Well, sa ngayon, nowadays kasi, what the court does is, well, may pairing judges naman per division, so at least yung proximity. But well, depende pa rin sa Supreme Court. Like for example, si Judge Janice Udarbe she is in Lucena, 'di ba? Pero she still has other appointments in Cavite kasi yun ang assign sa kanya. Siyempre, hindi naman niya pwedeng question niya. She might have chosen another closer court like in Laguna. Pero well, inassign siya sa Cavite. So dalawa yung hinahawakan niya. Aside dun sa regular sala niya diyan sa Lucena, meron din siyang other activities. I think nasa 13 siya ngayon. As we speak right now, meron siyang acting capacity sa 13 Martires eh. So yun yung paragraph 5.3 mo. So pwede mo sila. So it should not exceed 6 months. So minsan pag papaalam na minsan sa no one time na-assign I think si Judge Janice was assigned sa IMUS. So after lumipat na siya ng 13 after 6 months eh. So anyways, then of course number 4, order a change of venue or place of trial to avoid the miscarriage of justice. So ito yung People versus Pilotino, 'di ba? Si Bingbong Crisologo. But of course, syempre this has already been exercised a lot of times na. 'Di ba? Like si Mayor Sanchez, 'di ba? Nalipat sa Pasig yung kaso because of the perceived bias na pag sa Laguna Trinay. Sa Ampatuan Massacre, 'di ba? Although yung case was committed in Maguindanao, the Supreme Court directed that the case be tried in Quezon City. But of course, the place is in Cambagonia, but the sala was Quezon City. And recently, di ba, the greatest pastor of all time who has a lot of criminal cases and now running for senator right now, di ba? Hindi imbis sa Davao yung mga kaso niya, mga kaso niya nandito sa Pasig or sa Quezon City, yung mga kanyang mga cases. Because this is out of fear that if the case was done in the locality, in Davao City, there might be a miscarriage of justice. So, yun yung example niyan. Okay? Then of course, yung paragraph 5 na, yung section 5, paragraph 5, yun yung pinaka-importante. Okay? Yun ang pinaka-importante. The power of the Supreme Court to promulgate rules concerning the protection and enforcement of constitutional rights, pleadings, practice, and procedure in all courts, the admission to the practice of law, the integrated bar, and legal assistance to the underprivileged. So, yun yung power ng Supreme Court. Yung power nila to promulgate rules concerning pleadings, practice, and admission to the bar. It's absolute. If you can recall the case of Inreg versus Cunanan, di ba? Yung bar flankers case. This was first enunciated in the case. The Supreme Court cannot be override by Congress to determine who would pass the bar exam. Okay? It's only the Supreme Court and the Supreme Court only who can determine how they are going to admit the people in their profession, di ba? So, yun yung in the verse it's enshrined in our Article 8, Section 5, Paragraph 5. Okay? So, emphasize yan. So, if we can recall the case of so may mga statutes tayo, minsan nagkakaroon ng judicial overlap. Okay? So, dineclare unconstitutional siya. Example, sa Estipona versus Honorable Lobrigo, yung plea bargaining provisions ng RA 9165, it was declared unconstitutional because the concept of plea bargaining is something which is included sa pleadings and practice. Okay? So, since it's under pleadings and practice, those powers cannot be encroached by, these are powers that cannot be encroached by Congress. Diba? Hindi siya pwedeng i-encroach. So it will, sabi nga, diba? So, the separation of powers among the three equal rights has erected an impregnable wall that gives the power to promulgate of rules of pleading, practice, and procedure within the sole province of the Supreme Court. So the other branches trespass upon this prerogative if they enact laws or issue orders. Note that, syempre, BP 129. Baka ma-confuse kayo. Syempre, BP 129. It's a law, di ba? Creating jurisdiction. But note that may requirement yan na before a law creating jurisdiction will be made, there should be there's a required consultation or required consultation or advice from the Supreme Court itself before enacting that jurisdictional issues. Okay, so hindi lang sole province lang, although syempre it's a law, kailangan merong requirement that the Supreme Court may intervene or may require otherwise, di ba? Na kailangan meron kaming say diyan. Okay? Yun ang sinasabi ng Supreme Court. Okay? Then syempre, yun yung other, of course, yung huli kong emphasize sa Supreme Court is yung duration, yung period of time to submit cases for decision. So, alam mo, na-discuss nyo din to sa CrimPro at saka sa other aspects ng REM nyo. At syempre, just to recap, di ba, ang regional trial courts, they have 90 days to decide the case. The Court of Appeals 1 year, the Supreme Court 2 years. From submission of resolution. Okay? Note natin submission for resolution. Hindi kasama yung other delays before the submission for resolution. Of course, that's without prejudice to invoking inordinate delay, but we'll discuss that later on sa ano na, Constitu na. Okay? So, we're going to discuss, that will be discussed later in Constitutional Law 2. Pero, pero yun yung emphasis no. Now, of course, yung 90-day period, that's mandatory. Okay? Usually, ito yung ginagamit kung gamit na issue lagi sa questions din sa bar. I don't know if this was asked before sa REM or this was asked in a quiz somewhere. Ang tanong is this, ang question is, what is the nature of a judicial, what is the nature of the power of the judge to render a decision? Is it mandatory or discretionary? Yung bang power ng judge to decide, is it a mandatory power? Is it a ministerial? Di pa na mandatory. Is it a ministerial or a discretionary power? If you can recall, di ba, si concept ng ministerial versus discretion. Ministerial, the office does not have to do just to comply, di ba? Walang question. Di ba? You cannot challenge it. Pag discretionary, it appears that the officer may have discretion to do something. Of course, siyempre, yung isa kasi mandamos. Yung isa, pag nag-grave abuse ka, certiorari ka or prohibition. Depende sa gagawin mo. Pero, ang tanong is, yun nga ang tanong, what's the judge, the power of the judge to render decision? Is it ministerial or discretionary? Okay, let's go back to that question. The answer there is, it depends on what you are asking. Okay? Kung tinatanong nyo what you're asking is the merits of the case, okay? Hindi ministerial yan. Discretionary yan. Siyempre, the judge has to use his knowledge, di ba? To render a just decision for both parties. Pero kung ang pinag-uusapan natin is ministerial siya, sa kailan siya magiging ministerial? Pag ni-require siya na mag-submit ng desisyon. So, yung 90-day period, okay, yung 90-day period aspect ng RTC to submit, di ba? The case, di ba? It is ministerial. So, whether the judge likes it or not, the judge has to render a decision within 90 days. Otherwise, baka ma-sanction ka ng Supreme Court baka mo-suspend ka o matanggal ka sa posisyon, di ba? So, one good example is itong case sa harapan ko, si Oka versus Honorable Giling. Okay, so, nangyari dito sa Oka versus Honorable Giling, okay, well, si Judge, ang daming mga kasong puro tenga. Kasi, well, this is a family court. Nagkaroon ng parang, if you read the decision, the case itself, well, ang daming mga magic na ginawa yung sala, not only the judge, but some of the court staff, na dinidelay supposedly yung mga kaso, especially kasi this is family court, dinidelay kasi I don't know what they are trying to do or what are they trying to manifest to the people, to the lawyers there, di ba? Bahala na kayo mag-isip. Basahin nyo lang yung kaso. Kakaiba yung nangyari sa kaso. So essentially, sa pinagagawa ng mga shenanigans, hindi ang daming delayed sa submission. Laging hindi on time yung submission ng mga decision sa korte. So umakit hanggang OKA sa kaimbestigahan. Sabi ng Supreme Court, Article 5, Section 15, Paragraph 1 of your 1987 Constitution mandates lower court judges to decide the case within the reglementary period of 90 days. Then, of course, the new Code of Judicial Conduct directs judges to perform all judicial duties. So, rules prescribing the time for which certain acts must be done are indispensable to prevent needless delays in the orderly and speedy disposition of cases. Okay? Yung 90-day period na sinasabi dyan sa Supreme Court, okay, yung 90-day na yan, di ba, is mandatory. The speedy disposition of cases in our courts is a primary aim of the judiciary so that the ends of justice may not be compromised and the judiciary will be true to its commitment to provide litigants the constitutional right of speedy trial and speedy disposition of cases. Okay. Then, of course, we have yung contents ng decision. Note of the requirement. The decision must be based on the facts of the case and the law. Okay? kung walang determination ng facts at saka law ng case, your decision may be subject to a Rule 65. So, di ba, yun naalala niyo, tinanong sa bar exam, in relation do sa kaso ni G. Ju, di ba, yung nawalang Koreano. Di ba, nangyari doon sa RTC case, na-quit, na guilty lahat except yung mastermind. For some reason, yung iba niyang kasama na guilty siya, hindi. So, nung pag-akit ng appeal, well, ang ginawa ng Supreme Court, ginawa ng OSG, they did not appeal. Of course, what they did was they filed a Rule 65, okay? For grave abuse of discretion on the judge on determining. So, sabi dun sa case na yan, which is a CA decided case at sa tingin ko, mahirapang i-appeal yun. The CA decision would still be the case law there. Sabi ng Court of Appeals, hindi kasi sinight na Supreme Court na rin sa website nila yung CA decision. So, sabi ng Court of Appeals, mali yung pagkaka-exclude at quote-unquote acquit doon sa mastermind. Siya nga mastermind eh. Number two, the reason why they're also recalling the acquittal is because hindi clear doon sa desisyon na bakit siya inacquit. Ano yung circumstances, di ba? Siyempre, in a criminal case, in particular, and in any other case, kailangan i-explain mo yung pinanggagalingan mo ng batas based dun sa facts dun sa kaso. Lumalabas para ang nangyari, parang, well, they say daw that the decision was a total omission of the mastermind. Di ba? So, nangyari, ginangyari siya na sentensya ng Court of Appeals. They rectified it. They considered that the act of the trial court was meted with grave abuse of discretion. Okay? So, yan yung ano. So, note nyo, it should be based on the facts and based on the law. Ngayon, sa motion for reconsideration, okay, note that pag sinabi ng courts is, we do not find any cogent reason to disturb because it's a repetition of the facts. Compliant siya dun sa requirement na facts of the case and law, okay? Kasi syempre, you come to think of it, syempre na discuss nyo na yun sa main decision. You can just reiterate the final decision, okay? So that will be it for our discussion on the judiciary, okay?